Ministers, now Sri Amar Singh to open the discussion.
Thank you, sir.
Be very brief. Be very brief.
I will be very brief, sir. I will be very brief, sir. Very brief. Chairman, sir, as Honorable Minister has explained, that there is amendment in the 2019 Act to change the name of New Delhi International Arbitration Center to India International Arbitration Center. The second is there is an amendment in the section 15, I think, that all the rules, the regulation would be framed how to run it. Now, arbitration is a very good alternative method of disposal of the cases or disputes, or you can say dispute resolution. It's a very good method. And it has been going on in this country since ancient times. I mean, before independence, British era, even before that, our panchayats, our elders all used to do it. Britishers tried to bring law in 1889 and 1940. Then Government of India also brought one law in 1995. That was also establishment of International Center. And now in 19, this New Delhi International Arbitration Center. Sir, we all support arbitration center and alternative disposal of resolution of disputes between the parties. That principally it's a very good thing. But the question is, which I think has not been addressed in the amendment, we all know what has happened over the last 75 years, or even before that. Sir, you yourself, your government formed the Shri Krishna committee. That committee gave the report. Before that, there were two Supreme Court very strong judgments in 1989 and 2009. And the 2009 Supreme Court judgment, Union of India versus Singh Builders Syndicate, they say that there is a very, very unfortunate delays, high cost, frequent and sometimes unwarranted judicial interruptions at different stages are seriously hindering the growth of arbitration in India. That is a Supreme Court judgment. And this was 2009. Shri Krishna report also tells us the same thing, because we don't have statutory backup. There is lack of experts in the country. Generally, the arbitration tribunals don't stick to the cap on time for disposal of the cases. And various departments in Government of India and state governments, they appoint their own officers as arbitrators. That leads to litigation. And contrary to the belief that arbitration perhaps is the end of the issue, unfortunately, because in India, because the law, the order is not mandatory, it's not binding, so people can still go for appeals. Appeal. And unfortunately, in this country, we all know there are over 4 crore cases pending in various courts in the country. Sir, you are a law minister. You would be knowing much more than me. So, we have to bring some end to the litigation and to the arbitration. We are supporting everything, but 2-3 suggestions which I want to make. At least some certain legal or civil disputes could have been only delegated to this India International Center. There should be some clause in the law that the order would be mandatory, or there would be one or two appeals to High Court or Supreme Court. The litigation can't go on because there is no binding and you are keeping it still open. And 1995 International Center, there were 3 centers already working in the country, Bombay, Delhi, and there is another center. Not many results are coming. People are preferring Singapore Center, International Center. Why are they preferring? Because the orders are mandatory. And international experts are sitting on those tribunals. And the disposal is quite quick. Even Indian businessmen, Indian corporates, they are all going to Singapore for their disposal. But we are not touching those issues because of which people are going outside the country. People are going to Paris, people are going to London. Your intention is very good. But I don't find anything in the amendment which would lead to really solid results in the country. That is what my point is. Because we cannot, the name changing is good. India International Center would give some, New Delhi could have given a city-centric impression. That's good. But what happens to the orders? There is no finality of the order. There is no time limit. 60 days you have given in the Act, but no order is passed in 60 days. What is the provision to finish it in 60 or 70 or whatever days? I mean, there are so many practical problems in the arbitration issue. Unless we take up all those issues, simply changing the names, I don't think, and especially in disputes resolution,
Yes, Amar Singh ji.
it is the weaker sections of the society. It is the people with the lesser money. I mean, not the big corporate, smaller MSME, all those people. These are the people who are the sufferers because they can't afford the. Those lawyers which go to London and to Singapore. So please bring this law again.
Thank you.
And bring those amendments which are really needed to make this law effective. Thank you, sir.
Thank you very much. Now, Ramesh Bidudi ji.
धन्यवाद सर.
Please, very